All right, welcome to Judiciary Committee. Madam Clerk, members, if we can go ahead and get clocked in. Get punch in. You'll open the board there, please. All right. All right, Madam. All right, Madam Clerk, if you take the roll, please.
Mr. Chair, you have 14 members present. You have a quorum.
All right, very good. Members, any personal orders or recognitions before we get started? I have Representative Scarborough, and then I'll get to you, Leader Lamberth.
Thank you, Mr. Chairman, and welcome everybody here today. But I want to specifically, if I could, recognize our police chiefs in the audience today and Tennessee Association of Chiefs of Police. Thank you all for being here.
And I have Leader Lamberth. You're recognized, sir.
Thank you, Mr. Chairman. And look, if y'all been in any committees, I've been all day. I've been doing this all day long, but my little girl, Allison, is with us. That's Allison Lamberth back there. Most of y'all know her. Y'all please make her feel welcome. Thank you.
Members, anyone else before we get started? All right, good deal. Well, let's just start. Item 1, that's House Bill 1704 by Leader Lamberth.
Second.
So you got a motion and a second. I'm looking at House Amendment 13082. Is that something you'd like to move forward with?
Yes, sir, Mr. Chairman.
Very good. You got a motion and a second. Members, any objection to adopting House Amendment 13082 to House Bill 1704? All right, seeing none, all in favor say aye. Aye. Opposed? No. Ayes have it. Now we're back on the bill as amended, sir, and you're probably recognized.
Thank you, Mr. Chairman. It's a very simple bill. It makes it illegal, makes it an A misdemeanor to be an illegal immigrant in this state if you've had a final deportation order and a specific amount of time has lapsed, specifically 90 days. I stand ready for questions.
Very good. And members, I have two individuals who's asked to speak today, Amanda Hernandez, and I have Stephen Puckett. Are y'all here? Okay, looks like members, we don't go to session here from our guests. Any objection? All right, seeing none. Yeah, there's Mr. Puckett. If y'all come on up here, we're out of session now. We'll hear from you all. And I know Mr. Puckett, you've been there before. Ms. Hernandez, I think you may have, but just have a seat there. The red light will come on the microphone. You'll have 3 minutes each, and then we'll open it up for questions for the committee members. And we'll start with Ms. Hernandez, if that's okay. Or we can start with Mr. Puckett.
Yes, please.
All right, Mr. Puckett.
Let her start.
All right, just introduce yourself. Let us know who you're with, and you have 3 minutes.
Oh, I was going to say you're starting with me.
Yeah.
Okay. My name is Stephen Puckett. I'm a resident of Hendersonville, Tennessee. I speak for myself only, but I'm sure there are others that will share my views. I am speaking in opposition to this legislation because of the unique situation of illegal immigration, especially the importation side of it. This actually ends up it turns this legislation into a pro-trafficking and pro-racketeering bill by empowering the importation side, giving them more power to extort, manipulate, and abuse those that are brought in, especially through what's called intent trapping. This is waiver fraud. This is loophole scams. This is also rug pulling, pulling visas out, or even having someone call them in the immigration and timing them out so that they become felony entrapped, because they'll be penalized when they leave and when they stay because they didn't even know that they were in violation. So this is, and the thing is, I want to stress this, is if there was a way for this to work, the Biden administration would have sent it to Arizona yesterday as fast as they could. But the reality is, because of the importation side, this is virtually impossible to prove for these individuals to be able to defend themselves and prove their status, prove that they're innocent. Sorry. So this is for me, this is a real big challenge because as someone who, my job, stocking grocery shelves, it is directly threatened by illegal immigration because the companies you're contracting to replace people like me. And this is the weapon they use to exploit these people and steal from them. And it makes us both victims. The only way to really end this type of illegal immigration issue is going to be to tax these companies. And the worst offenders are the ones using horizontal shareholding to get to extract the profits to the point that they are virtually untouchable outside of a full market tax. So
All right. Thank you, sir. You have your 3 minutes. Appreciate that. Mr. Hernandez?
Yes. Thank you so much for bearing with me.
You're welcome.
My name is Amanda Hernandez, and I'm here in respectful opposition to this bill. House Bill 1704 seeks to create a Class A misdemeanor offense parallel to U.S. policy on the presence of undocumented immigrants. But we have already seen this play out earlier last year in another state, wherein the Supreme Court denied their appeal for an injunction, signaling that they would believe the overall appeal would ultimately fail. It is and always has been clear that immigration enforcement is the purview of the federal government, and there is an entire line of jurisprudence that governs this in the United States. As referenced in the bill's summary, the misdemeanor offense cannot be codified until and unless either the Supreme Court overturns the Arizona v. the United States ruling or the federal government removes the prohibition of a state's ability to determine the lawful or unlawful presence of an individual. Given the very recent loss of the state to the ACLU of Tennessee regarding last year's statute criminalizing elected officials voting in favor of sanctuary policies, I believe we should be focused on using taxpayers' money on community benefits like education, affordable housing, and healthcare. We are 45th in per student funding, according to the National Education Association, 31st in education, according to U.S. News and World Report, last in maternal mortality at 42.1 deaths per 100,000 live births based on a study done by the March of Dimes, and the average rent for a 2-bedroom apartment where I live is almost $2,000 based on the 2025 report from U.S. housing data. This legislation does nothing to improve the lives of Tennesseans and instead only works to further an already unpopular federal agenda. Regardless of where we stand politically, we should agree on a few principles. Immigration enforcement is a matter of federal law. We should not duplicate federal enforcement mechanisms. We should protect taxpayer dollars from avoidable litigation, and we should ensure our law enforcement resources remain focused on serious public safety threats. For these reasons, I urge you to vote no on this bill. Thank you for your time and consideration. I am happy to answer any questions.
And thank you. Members, any questions for our guests? Representative Johnson, you're recognized.
Thank you, Mr. Chairman. So you mentioned a little bit about federal law. Wouldn't this bill be unconstitutional as relates to federal law?
Y'all can go ahead back and forth. Just try not to speak over one another.
So I will preface this with, I am not a lawyer. I am a legal hobbyist. So I would believe so, especially under the supremacy clause. But there is, as I mentioned, a whole line of jurisprudence that could be referenced in this. But my personal opinion would be yes.
Okay. I was specifically thinking Arizona versus U.S. So,
Correct. Yes.
yeah. Thank you.
Any additional questions? Members, while we're out of session? All right, seeing none. Thank you all for being here. All right, without objection, we're going to go back into session. All right, Representative Salinas, you're recognized.
I had questions for legal. That's what I was trying to get.
We can do that now.
Oh, in session?
We'll go back
Okay.
out.
Okay. That's
All right. Are you asking to go out of session here from legal?
Yes.
Very good. Members, any objection? All right, seeing none. All right. Representative Salinas, you're recognized.
Yes. Under state law, would we have to provide representation for criminal cases?
The state is obligated to provide representation for defendants who are indigent.
Okay, so if a person that was in immigration court got transferred to criminal court and is indigent, the state would have to provide representation for that person.
Yes, if they are charged with a criminal offense, yes.
Under state law, who pays that?
Indigent representation is paid through the Administrative Office of the Courts through state funds.
Okay. I don't, I'm going to ask this question, but I'm not sure that you will know the answer, but I think something I have. So this is an immigration case, but then we're in criminal court. That representation that we would be required to provide, would it be a criminal lawyer or an immigration lawyer under law?
Section 1 creates a criminal offense of intentionally failing or refusing to depart from this state within a period of 90 days from the date of a final order of removal. So it's a criminal offense. So this would be an offense that's prosecuted in criminal court.
So it would be a criminal lawyer.
Yes.
And most crime lawyers don't have experience in immigration.
The elements of the offense are just that they intentionally failed and refused to depart from this state within a period of 90 days from the date of a final order of removal that's issued under an administrative process. So the state would have to prove the elements that there was a final order issued and that within 90 days the person failed or refused to depart from the state.
Okay, thank you.
Members, any additional questions for legal? Representative Johnson, you recognize.
So we have to provide a lawyer. Do we have to provide an interpreter? Does the state have to pay for that as well?
Michelle Fogarty, Legal Services. My experience is that the state already does provide interpreters for persons who cannot speak English in criminal courts.
Thank you.
Members, additional questions for legal? All right, seeing none, any objection, going back into session? All right, seeing none. All right, we're back on the bill. Leader Lambert, you recognize?
No, Mr. Chairman, it's quite straightforward. I mean, when someone has exhausted all of their options and they've been told to leave the country, it is illegal for them to stay, both under federal law, and if this bill passes, it would be an A misdemeanor for them to enter in or remain in the state of Tennessee.
Representative Johnson, you recognize?
All right. It's currently a civil penalty. It's not a criminal offense in most cases. So everything that I've read, everyone that I've talked to said that this is currently unconstitutional. Is that a problem for you? Is this one of those Stephen Miller bills at any cost to the Tennessee taxpayer that we're passing something that we know is unconstitutional?
Leader Lambert.
I'm glad you bring that up. I like our track record of the U.S. Supreme Court. See, when we were trying to keep doctors from mutilating children and cutting out body parts, you all argued it was unconstitutional. We went all the way to U.S. Supreme Court. They disagreed. That's now the law of the land. We argued you couldn't kill babies in the womb. You all disagreed. It was unconstitutional. Quoted Roe v. Wade. Guess what? That got overturned as well. This makes it a criminal penalty. This makes it a criminal penalty. This makes it a criminal penalty. And it makes it an A misdemeanor in the state of Tennessee to remain here as an illegal immigrant. If you're a legal immigrant, you are welcome in this state. If you're an illegal immigrant, you need to go home back to your country. There's 8.3 billion people in this world. They can't all fit in the United States, and especially in the state of Tennessee. They have to come here legally.
A lot of these folks do come here legally, and that legal status has been taken away by the current administration. We have put people in this position in so many circumstances. And, the talking point from some of my colleagues has always been, oh, but they're doing something illegal. They are not. And proof that they were not doing anything illegal, that it was a civil penalty, not a criminal penalty, is the fact that now you're trying to criminalize it to go along with your former talking points.
Sure. Very good. I have Representative Travis. You're on the list. You're recognized.
Thank you, Mr. Chairman. I move previous question.
All right. Previous question's been called. There's objection. Members are going to be on the board. Madam Clerk, if you'd open the board, members, those in favor of previous question, vote aye. Those opposed, vote no. Has every member voted? Any member like to change their vote? Very good. Madam Clerk, take the vote.
Mr. Chair, you have 11 ayes, 8 noes, and 0 present not voting.
All right. Previous question fails. Leader Lambert, you recognize.
Thank you, Mr. Chairman, and I'm glad you brought that up, friend from Knox County. Last year, there were 41 people that were killed by illegal immigrants in this state. 2,183 violent offenses, 1,582 assaults, many of those aggravated or assaulted an officer. There were 145 sexual offenses, including 11 child rapes committed by illegal immigrants. You may not like the facts, but illegal immigrants are committing crimes in this state, and they should not be here. There were 2,920 DUIs and 40 aggravated kidnappings, all committed by illegal immigrants. All committed by illegal immigrants. If you will not abide by the laws of this country and this state, they should go home.
Very good. I have
That is
Representative-
racist, and you know it.
I have Representative Garrett. Sir, you are recognized. Representative Garrett, you are recognized. You're on a list. If not, I'll pass. We can move down. Okay.
Thank you, Mr. Chairman. I move previous question.
Very good, members. That's a proper motion. Previous question has been called. There is objection. We will be on the board. Madam Clerk, if you'd open the board. Members, all those in favor of previous question, vote aye. Those opposed, vote no. Has every member voted? Any member want to change their vote? All right, Madam Clerk, take the vote.
Mr. Chair, you have 15 ayes, 5 noes, and 0 present not voting.
Very good. Previous question prevails. Members, whether or not to send House Bill 1704 as amended to calendar and rules. All those in favor, vote aye. Madam Clerk, open the board. All those in favor, vote aye. Opposed, vote no. Has every member voted? Any member want to change the vote? Very good. Madam Clerk, take the vote.
Mr. Chair, you have 15 ayes, 5 noes, and 0 present not voting.
Very good. House Bill 1704 as amended is moving to calendar and rules. All right, Representative Johnson, you're recognized.
Yeah, I was confused. We had a request for previous question, and then we voted on the objection, correct? And then instead of then voting, we went back to Lambert. Why did we do that? Oh, did the objection fail?
Right, the objection failed, and
Thank
that was announced. Okay, very good. Any additional questions? All right, members, very good. That brings us to item 2, House Bill 1900 by Leader Lambert. Sir, you have a motion and a second. I'm not seeing any amendments on this bill, so you're properly recognized.
No, sir, Mr. Chairman, this provides for that, years ago, we created the lifetime order protection for those that have been victims of violent crimes so that if the judge determines that they've been the victim of certain criminal actions, then they would never have to see that person again. And this would allow for convictions that occurred in other states to still be applied here for a lifetime order protection to be granted.
And thank you for that explanation. Members, any questions for Leader Lambert? All right, seeing none. Any objection to the question? All right, seeing none. It looks like we're voting to send House Bill 1900 to calendar and rules. All those in favor, vote aye. Madam Clerk, open the board, please. All those in favor, say aye. Vote aye. Opposed, vote no. Everyone voted. Anybody want to change the vote? All right, Madam Clerk, take the vote.
Mr. Chair, you have 20 ayes, 0 noes, and 0 present not voting.
Very good. Item 2, House Bill 1900 is moving to calendar and rules. That brings us to item 3. That is House Bill 2279 by Leader Cochran. And members, without objection, we're gonna roll that to the hill. Oh, I'm sorry. Item 3, House Bill 2279. I'm looking at Chairman Todd. Looks like he's gonna be carrying the bill. Very good. You got a motion and a second, and I have looking at House Amendment 13441. Is that something you'd like to move forward with?
Yes, please.
Very good. You've got a motion and a second. Members, do we want to go ahead and adopt that amendment? Any objection? All right, seeing none. All those in favor of adopting House Amendment 13441 to House Bill 2279, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and Chairman Todd, you are properly recognized.
Thank you, Mr. Chairman. The Crush Transnational Repression in Tennessee Act creates a new criminal framework to protect Tennesseans from intimidation, harassment, coercion, or enforcement activity carried out on behalf of foreign adversaries or foreign terrorist organizations. The bill enhances penalties when crimes are committed under the direction of a foreign regime or terror network, creates a new felony offense for unauthorized foreign law enforcement activity inside the state, and ensures constitutionally protected First Amendment activity is not impacted. The legislation also prevents Tennessee courts from enforcing foreign court rulings, arbitration decision, or contracts if doing so would violate rights protected under the U.S. or Tennessee constitutions. In addition, it requires state agencies to establish complaint pathways for victims of transnational repression, and the act takes effect on July 1 and includes severability language to preserve the remainder of the law if any portion is challenged.
Very good. Members, any question for Chairman Todd? Representative Johnson, you're recognized.
Thank you, Mr. Chairman. So a lot of this is already illegal. Can you tell me what's new that this bill is doing?
Chairman Todd, you recognize.
Is it the enhancements? Is that it, or is it doing other new things?
Thank you, Mr. Chairman. It's just as I described, it does enhance penalties when crimes are committed under the direction of a foreign regime or terror network.
And what is that from what level to what level?
Any criminal offense other than a Class A felony is punished one classification higher when committed by an agent of a foreign adversary and so forth.
Okay, and last question. It says the state, like the TBI will monitor this. Is this not something that should be monitored by the FBI or the CIA since it's federal involvement?
This says that each state agency must include these, the repression and awareness in their policies and procedures, and provide a direct pathway for individuals to file complaints. It builds a statewide reporting and response capacity.
And so it doesn't put it under the purview of TBI?
I do not believe so. It's like I said, this is Leader Cochran's bill, and obviously he can't be here today, so I'm pinch hitting, and so I don't have the answer to that right offhand, other than what I've already answered.
Can we roll this bill till next week so that he could be here?
Second.
Objection.
Some pretty fundamental questions I think that we should have answered.
The bill addresses in Section 6 your exact question,
And what does it say?
what I just read.
Is it under the
Each-
purview of TBI was my
Each
question.
state agency. So TBI would be involved, but each state agency has this responsibility.
And are they coordinating with feds or how does that work?
There's no mention of federal involvement in this, I don't believe.
But it's the federal situation.
Okay. Members, I'm thinking that it would have to be the Tennessee Bureau of Investigation, the Department of Safety, or Tennessee's Department of Homeland Security, which are all the three probably, I'd say, probable state agencies that would be involved here. Leader Lambert, you recognize.
Mr. Chairman, everything you said, and it's all written right in the bill. I mean, it's in the language of the amendment. And I commend Chairman Todd for carrying the bill. Obviously, Representative Cochran's father passed away yesterday, so he is not here. And I'm not saying that so that folks don't ask questions. Ask all the same questions we would, but some of these we may have to go to legal for or something else. We're all trying to fill in and help out a representative who is unable to be here. But it is in the language. I don't think in any way Chairman Todd's being dismissive of the question or not answering it. It is just the language of the bill is what we have to go by today. And Mr. Chairman, if legal would like to, or if any of the representatives have a question for that, anyways, I just want to bring it up.
All right, Chairman Todd, you recognize.
And this only involves the state, does not involve the federal government at all. And Chairman Farmer was correct on his assessment of who would be involved.
Very good. Representative Salinas,
Can we go to legal?
we address it on microphone. You recognize.
Can we go to legal on some of this?
Members, any objection to going out of session here from legal? All right, seeing none. All right. You recognize. Or, Representative Salinas, if you have questions, Ms. Fogarty, we'd be happy to answer those.
Yeah, so would TBI fall under this?
Michelle Fogarty, Legal Services. The bill, it creates enhanced punishment for offenses that are committed in a certain manner. It also creates a new criminal offense. So any law enforcement agency in this state would have the ability to investigate or arrest for that criminal offense, including the TBI and the Department of Safety officers.
Okay, thank you.
Very good. Representative Johnson.
And thanks. And understand, I do want to vote for this bill. I really just want to understand how it works. And that's what these questions are about. So I feel like I need a little more information. I did look at this bill and these questions were brought to me from attorneys. So, they are legitimate questions.
Representative Powell.
Thank you. I was reading over the, I guess, specifics of the bill. Could we take a step back, I guess, and tell me the intent of the bill and why it's needed? That would be helpful for me to kind of.
Okay, we're still out of session. That's a
Oh, sorry.
that'd be a policy
Yeah,
statement.
sorry,
So any
sorry.
additional questions for legal while we're out of session? All right, seeing none, any objection, going back into session. All right, seeing none. Chairman Todd, you recognize, sir?
Thank you, Mr. Chairman, and I will restate what the purpose is. It is to protect Tennesseans from intimidation, harassment, coercion, or enforcement activity carried out on behalf of a foreign adversary or foreign terrorist organization.
Representative Powell, did that answer your question? You recognize.
I guess, is foreign adversarial organization defined in the code previously, or are we defining that within this bill?
And I believe that's defined in the bill, Chairman Todd.
Yes, in section 3, number 3, foreign adversary means the country specified in 15 CFR 791.4A or a successor regulation.
All right, just a follow-up. Could you give me a concrete example of what and why this is happening, or what we're trying to address with this?
Chairman Todd.
I don't have an example per se. I could probably make up one, but I don't have a personal example that I know of. I didn't get to speak to Leader Cochran about this to see what issues he has noticed or what someone has brought to him to solve. I will say that foreign adversaries carrying out these things need to have punishments. We need to be able to go after them when they are infringing on the rights of our citizens.
Very good. Members, any additional questions for the sponsor? Seeing none. Any objection to the question? All right, seeing none. All those in favor of sending House Bill 2279 as amended to calendar rules, vote aye. Madam Clerk, if you'd open the board. All those in favor, vote aye. All those opposed, vote no. Has everyone voted? Anybody want to change the vote? All right, Madam Clerk, please take the vote.
Mr. Chair, you have 18 ayes, 0 noes, and 3 present not voting.
Very good. House Bill 2279 as amended is moving to calendar and rules. And next on, let's have item number 4, House Bill 661. Looks like we have Chairman White. Welcome, sir.
Thank you.
And you've got a motion in a second, and I have a slew of amendments, but it looks like House Amendment 13983.
That is correct.
Very good. You got a motion in a second. Members, do we want to go ahead and adopt this amendment? Very good. Any objection to adopting House Amendment 13983 to House Bill 661? All right, seeing none. All those in favor vote aye. Aye. Opposed, vote no. Ayes have it. Now we're back on the bill as amended, and you're properly recognized.
Thank you so much, Chairman of the committee. This is known as the Batterers Intervention Program. Worked on this last year and this year, and I really want to give a lot of thanks to our leader Lambert for helping me work through the judiciary part of this. So this bill would have the most impact, but yet not get tangled up in judiciary. It's called the Batterers Intervention Program. We know that when a person commits domestic violence, it usually stems from a long history of violence stemming back even to their childhood. And so we know that when a person commits domestic violence, as they become an adult, a short-term program or a short-term arrest doesn't really change the behavior. It's very, very difficult, as we all know. So as part of a defendant's alternative sentencing, this allows a judge to direct the defendant to a certified batterers intervention program that meets Tennessee Code 3812-110 that regulates the batterers intervention program. About 40 of our counties, not only if they the judge has in that county, not every county does. Right now we have about 40 counties in Tennessee who have this certified program. But where the meat is, the program is a minimum of 26 weeks and no more than 48 weeks, but must have a ratio of 1 counselor to 6 defendants and no more than 10 defendants per class. And each class would last 2 hours. If the defendant does not complete, then the judge may revoke the participation in the program and then go back to the original sentence, which may be jail or prison time. And that's really what the bill does. It sets up this intervention program to deal with domestic violence, which is long-term in many cases.
Very good. Appreciate that explanation. Members, any questions for Chairman White? Representative Johnson, you recognize.
Thank you. So a question from some of the agencies in my county is that, does this remove the judge's ability? So example, 2 roommates who are drunk get in a fight. That's they can get charged with domestic violence. And a batterers program is really more about relationship between partners. And maybe these folks need to go to an alcohol program or an anger management program. Does this say the judge has to send them to this batterers program that may not apply to them, that other programs would be better? Because that's the concern. You're going to send folks to a program that doesn't really address what their particular issue was. Does the judge have the ability to send to anger management maybe instead of a domestic abuse program, which doesn't fit their situation? And the other thing is, this doesn't pay for it for indigent folks. And what if it's a situation with a husband and a wife, and maybe the husband's the breadwinner? What they're afraid of, it's going to keep women from pressing charges because they're actually going to have to pay for the program for the batterer. And so those are just some concerns brought to me from agencies around. So can you speak to those?
Chairman White, you recognize.
Not to the detail of that, what you're bringing up. The bill does say that the sentencing judge shall direct the defendant to a batterers intervention program. Now, as far as all the legalities of what's going on in the courtroom with the judge and his options on all the cases you brought up, I cannot address that. What we are trying to address is that when you have, if there's domestic violence in the home and the police arrest them, and then they're right back in the home or back on the street 24 or 48 hours later, nothing changes. So this is just more of a long-term intervention program for the batterers intervention.
And I absolutely appreciate that. But my concern is in situations that aren't, between a couple where the batterers intervention program addresses other issues, people in different situations that would be served better in other programs that address their particular issue are going to have to pay for the batterers program that doesn't address their issues. And I guess the judge can assign them multiple programs, but shouldn't we allow the judge to make that decision of which program they need to go into? Because it's going to be a financial burden, and also how much time. This is a pretty intense program, which is good if it's for who it's intended, but it's so broad. It's going to include a lot of people that are not in this type of situation, but they're going to be forced into that type of program that doesn't address their issue. That's my concern.
Very good. And I see this, I'll say that in my practice, I've done quite a bit of criminal defense work and represented a lot of folks who have been charged with domestic assault. And regardless whether it's a father, stepson situation, roommate situation, most of all the judges I've been in front of are already ordering these defendants to attend this program. It is broad, but I think it is good for those to understand how to control their emotions in a tough situation like that. So I think it's a good program. I think it's a good bill. But for what that's worth, Chairman White, you're recognized.
No, thank you very much. Yeah, and there's a lot of issues. That's one reason we worked on this for 2 years. It seemed like every time I got down the road to address a program that can have effect, you run into a lot of the questions, such as the representative had brought up. But I think it's, like you said, I think it's a good program. We can always tweak these things going forward, but domestic violence is a serious thing. It's a long-term thing, and you just don't work out of it by being arrested or sent to jail for 3 or 4 days or whatever. Thank you.
Very good. Any additional questions? Members, I have Representative Towns. You're next on the list, sir. All right, Representative Johnson, you're recognized. Go ahead. You're recognized, yeah.
So did you think about trying to, is there a way to address it where we don't put those other folks in there? I mean, I don't necessarily know what that'd be because you're the one that's been doing the work on the bill, and I would love to find a way to make it really apply to the folks, only the folks that it should. I feel like that's important.
Yeah.
Chairman White.
Good suggestion. I've gone through so many versions of this, trying to get something that we can address for this particular thing.
And Representative Towns, you can always bring a bill to do that if you choose to do so. Representative Towns, you're recognized.
Thank you very much, and thank you for bringing the bill in. Comments that I've heard. Question for you: will the judge be able to sentence the defendant to this class versus going to stay in jail?
Chairman White.
From what I understand, and I can stand to be corrected, the judge will always have the discretion on that if whatever he wants to do. But I think this just gives another option. This certified batterers program, like I say, it's in 40 of our counties, which is a very effective program. So I think it just gives the judge a little leeway where he thinks this will work better than because a lot of these are repeat offenders too.
President Towns.
And I think he needs flexibility and options. 40 counties that the program is currently in, have we, and I think it's a good program, no question, but have we tracked the data to see how effective it is? We're saying it's effective, but do we know numerically how many, if they're repeat offenders, how this program has impacted them where they get out of the system? Have you had a chance to look at that?
I have not.
Okay.
I don't have that data, but this one reason it's only in 40 counties because it does take instructional time, and we don't have someone in every county that's able to do this.
Well, Mr. Chairman, we're making a good attempt, I think, and I'd love to see some numbers, but on the surface, on the face, I think it certainly will do good. 2 or 3 days is not going to cool people down. Conflict resolution, I don't know what they're teaching in the deal. Domestic and conflict resolution, how to resolve something without violence is very, very critical and necessary. And I hope they're teaching. I'd love to see at some point what kind of, issues they do address, but thank you for the bill.
Very good. President Chair, Leader Lambert, you recognized.
Move previous question.
Very good. Previous question has been called. Any objection? All right, seeing none. Members, looks like we're ready to vote to send House Bill 661 as amended to Finance, Ways and Means. Madam Clerk, if you'd open the board. Members, all those in favor, vote aye. Opposed, vote no. Has every member voted? Any member wish to change their vote? Madam Clerk, you would take the vote.
Mr. Chair, you have 17 ayes, 1 no, and 2 present not voting.
Very good. House Bill 661 as amended is moving to Finance, Ways and Means.
Thank you, committee.
You're welcome. Members, and without objection, I'll move to item 8. Representative Gillespie. House Bill 1449. And I'm looking at House Amendment 013676. You got a motion and a second. Members, we want to go ahead and adopt that amendment. Any objection? Seeing none. All those in favor of adopting House Amendment 13676 to House Bill 1449, say aye. Aye. Opposed, say no. Ayes have it. And it looks like, Representative Gillespie, are you going to run that amendment, or Leader Lambert? Is that, I have your name underneath it for some reason, but if Gillespie. Leader Lambert.
Move to adopt.
We did that a second ago. We're in good shape. We're on, the amendment's on, so we're good. Representative Gillespie, you're recognized.
Perfect. Thank you so much, Chairman and committee. And all that amendment did was renamed it back to the original classification from street drag racing to drag racing. So members, this bill is my last attempt at the drag racing dilemma in the state of Tennessee. As introduced, what this will do is it will expand the offense of drag racing to include acts committed on commercial property, authorizes a vehicle used in the commission of the offense, or to flee after the commission of the offense to be impounded for the purpose of collecting evidence. It also expands the definition, whereas to drifting, donuts, stunts, and then reckless driving for the sole purpose for spectators. This would also mirror what we currently do with DUIs. It would allow for or require an arrest of the offenders as opposed to just a simple citation, see you in court at another time. I don't know if y'all saw last night here in Metro Nashville, there was a high-speed race and chase. They were going over 140 miles an hour. Metro's helicopter, I'm not sure could keep up, but was having a hard time keeping up. So this is still very much an issue. And with that, I renew my motion.
Very good. Chairman Doggett, you recognized.
Thank you, Mr. Chairman. Sponsor, is this, when you talked about the seizing of this vehicle, is that going to be civil forfeiture? Or is it going to be criminal forfeiture?
Representative Gillespie.
Thank you. It's my understanding that it would be, it's not a permanent seizure, so that would not be a civil forfeiture. It would be at the time of the arrest. And then just like evidence is currently utilized, or excuse me, just how a vehicle or a pencil could be utilized as evidence, that would be the same case.
Chairman Doggett.
And so the defendant in this case would have an opportunity to get this vehicle back.
Representative Gillespie.
That is my intent, if they are not convicted.
Chairman Doggett. You are recognized.
I noticed there was a lengthy discussion over here. Can we go out of session to hear from legal about my question? Clarification.
Members, any objection to going out of
Is it
session here?
needed? Can you clarify?
Very good.
Can you clarify?
Let's go out of session. Let's
Okay.
let's let Ms. Fogarty handle that. Members, any objection for us going out of session? All right, seeing none.
Sidebar.
Michelle Fogarty, Legal Services. Could you repeat the question again, please?
I had asked the sponsor if the seizure of that vehicle would fall under criminal or civil.
So the bill as written allows the vehicle to be impounded for the purposes of collecting evidence, and then it is subject to seizure upon conviction. So it would be a criminal forfeiture after conviction for the offense.
Very good. Thank you.
Members, any additional questions for legal? Seeing any objection going back into session? All right, seeing none. Members, any additional questions for our sponsor? All right, I have Representative Powell. You recognize, sir.
Thank you. And I just want to say, I know passed a bill a couple of years ago. They actually created a speed racing task force that worked on different legislation. I think this bill was part of that. They came out a recommendation for it. This is a significant issue. I know that might have what you just referenced have happened in my district. But I know that people have literally turned these vehicles into weapons, where people are just out in their neighborhood trying to enjoy, feel safe and comfortable. And I know that, unfortunately, kind of during COVID, this issue sort of really grow and increase. And there was thoughts that maybe this would die down a little bit, but it seems like it's only gotten worse. I think we really need to, I have some things that I'm usually pretty cautious on that are in this bill, but I think that this continues to be a problem that people are taking seriously. And so we've got to continue to have tougher consequences because the speed racing, it's taken lives. I've witnessed these accidents following one personally. And, under the bill that we named it after was actually a U.S. veteran who was killed in a speed racing incident that created that task force. So appreciate the bill, but feel free to speak to any of that. Thank you.
Very good. Members, any additional questions? I have Representative Towns, sir. You're next on the list.
Thank you. And thank you for the bill as well. I'm sure many of y'all have been on the expressway or driving where these cars are coming so fast, you can feel it as they're coming by you. It almost pressurizes your environment. You'll be doing 100 miles an hour, 120, whatever it is. You don't even see it. If you don't look 3 or 4 times, you're getting ready to make a turn, you're going to get clocked. You're dead. You're definitely dead. No question about it. Question I have for you is that once the cars are seized under a criminal forfeiture, where does the money go? And what happens if there is a note on the car? You just got the car, acting a knucklehead and doing all that speed, but he has a note on the car. How do we address that? And then if there's no note on the car, where does the money go to? It goes to the general fund, or where are we sending the money for that vehicle?
Representative Gillespie, you recognized.
Thank you, Mr. Chairman. We may have to go to legal for that. I will just reference Section 7, Part 2. It just says, upon conviction of the offense, subject to seizure and forfeiture as provided by Title 40, Chapter 33, Part 1.
Representative Towns.
If I'll take the suggestion and ask legal if we can clarify it. I mean, at the end of the day, there may be thousands across the state. We need to figure out what we're going to do with the resources. Maybe put in some kind of driving program. I don't know, but I'd love to hear from legal, Mr. Chairman. Hate to do that, but I'd love to see on the front end.
Representative Gillespie.
Thank you so much. If I may, and I'm staying on the topic of my bill, or on this situation. I have had bills in the past with drag racing, and the offense and the penalties would go to the traumatic brain trust and fund.
Okay.
I don't believe that this does that, but I'd be welcome for that to happen.
Right.
Very good. Members, any objection going out of session here from legal? All right, seeing none.
Michelle Fogarty, Legal Services. I believe if there's a note on the car, they pay off the note. And then the funds would revert to the seizing agency, I believe.
Seizing agency.
Representative Towns, any follow-up?
No, she says the seizing agency will receive the money. Okay, if that's what it says, I'm fine. Thank you.
Okay.
Thank you, sponsor.
Representative Powell.
Just a question to clarify. So if the person uses a car that's, say, their grandmother's car and they borrow it, or it's a friend's car that they have taken without their notice, or another scenario like that, is it still subject to this, or is it just if they own the vehicle?
So under criminal forfeiture, the statute says all conveyances seized under this part shall be sold at public sale by the county sheriff at the direction of the court having jurisdiction. I think you may be thinking about civil forfeiture, where there's lien holders and interest holders. But under criminal forfeiture, this statute says that it shall be sold at public sale.
So just to clarify, I guess if it's a stolen car and someone's driving it and it's under this, then could it still be subject to this? Criminal?
Well, the bill says it's subject to. It doesn't say that it absolutely has to be seized and forfeited. It's subject to seizure and forfeiture. So I would think that would be up to the agency that originally brought the charges.
Very good. Any additional questions for legal? Members? Any? Representative Towns, you have a question? Okay, very good. Members, any objection going back into session? All right, seeing none. All right, Representative Towns, you recognize. You have a question?
Thank you. Chairman Powell brought up a good point. Like the bill, but if a wayward rascal has stolen his car, his grandmother's car, or his mother's or dad's car, and or someone's car in the neighborhood, as we pass the bill, maybe we can do a little amendment that says those cars don't. You add someone to it that says those cars that are stolen don't become sold, where that grandmother or that mother can get their car back, or whoever. I'm sorry. Go ahead.
Leader Lambert, you recognize.
Oh.
Thank you, Mr. Chairman. And look, under criminal asset forfeiture, if there is a lien, if it belongs to somebody else, if the car is not that person's car, it goes back to the real owner. If they own the car and they are drifting and drag racing and doing illegal stuff with it, then they could lose that car, but they have to own it. The bank owns it. If your mama owns it, if your buddy owns it, if you stole it, it goes back to those people. Mr. Chairman, is that fair enough?
Very well stated,
Thank you,
sir.
Mr. Chairman.
All right, members, any additional questions for our sponsor? Any objection to the question? All right, seeing none. Members, we're going to be voting to send House Bill 1449 as amended to Finance, Ways, and Means. Madam Clerk, if you'd open the board. Members, all those in favor vote aye. Opposed, vote no. As every member voted, would any member like to change their vote? Very good. Madam Clerk, if you take the vote.
Mr. Chair, you have 18 ayes, 0 noes, and 2 present not voting.
Very good. House Bill 1449 as amended is moving to Finance, Ways, and Means.
Thank you.
You're welcome. That brings us back to item 5. I have Representative Baum, I believe. There you go. That's House Bill 1450. Sir, you have a motion in a second. I'm looking at House Amendment 14298.
Correct.
Very good. You have a motion in a second. Members, we're going to go ahead and put that on. Any objection? Seeing none. All those in favor of adopting House Amendment 14298 to House Bill 1450, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're properly recognized.
Okay, thank you, Chairman Farmer. When someone is arrested and they're taken to jail waiting for a court hearing, they can get out of jail one of several different ways. Number one, they could post bond themselves. Number two, they could have a family member or a legal guardian or an employer posted on their behalf. Number three, they could use a professional bail bondsman. Or number four, some other entity could post bail on their behalf. And this is a bill that would affect that fourth category, which would include charitable bail funds. In particular, what the bill would do is it would take for that fourth category and it would put on two restrictions. The first restriction is it would say that a member in that fourth category could not bail the same person out more than one time per year. And the second restriction is that the amount of bail posted by that group in this fourth category couldn't be more than $5,000.
And thank you for that explanation, sir. Members, any questions for our sponsor? All right, Representative Johnson, you recognize, ma'am.
We have quite a few organizations, community organizations, nonprofits that help folks who struggle with different issues that are adamantly opposed to this bill. They help pay for bail funds for some of these folks and have much higher than a 90% rate of those folks showing up. And I'm just confused about why we would try to eliminate that service that they are providing to help folks in the community.
Very good. And I missed something earlier, members. I had a Mr. Josh Spickler who had asked and put in notice to speak today. Josh, are you here? Yes, sir. Members, any objection going on a session here from Mr. Spickler?
No.
All right, see none. Very good. Sir, if you go ahead and step up here. Sorry, I missed you. Generally, I do that in the beginning of a bill. If you just have a seat there, your red light's on. You'll have 3 minutes. Just introduce yourself there and give us what you got, and we'll have questions for you later.
Thank you, Chairman Farmer. I'll be brief. Thank you, members of the committee, for this opportunity to speak. My name is Josh Spickler. I'm the executive director at Just City in Memphis, and I represent the Memphis Community Bail Fund, a project that we started a little over 8 years ago. While we don't necessarily believe legislation like this is necessary, I'd like to thank the sponsor, Representative Baum, for listening to us and for recognizing the important role that community-supported bail plays across Tennessee. If you're not familiar with the Community Bail Fund, this is how it works. We take donations, and when we get a referral for someone who has a low-level bond, we pay that in the full cash amount. And once that person's case is over, as long as they make all their court appearances, we get all of that money back, and then we do it again. At its heart, bail funds are about neighbors helping neighbors. We believe that a person's ability to remain with their family while awaiting their day in court should not be determined by the balance in their bank account. In Memphis, we've seen that when people feel supported by their community, they show up. Our bail fund has an appearance rate of more than 98%. 98% appearance rate. This isn't because of a financial threat or what some might call skin in the game, but because of the accountability and connection that comes from community-led support. Our automated text message reminders probably help as well. Without this community support, people would sit in jail for weeks or even months before their guilt or innocence is decided. In that time, a person can lose everything: their job, their vehicle, their home, precious time with their children. Community bail funds ensure that people can stay in their homes, remain connected to their families, and keep their jobs while their cases move through the legal system. Our bail fund focuses on smaller bail amounts because we know that for many families, $500 or $1,000 is an impossible hurdle. And by stepping in, we aren't just paying a bond, we're playing a small but critical role in the criminal justice system. Community bail funds value people and the vital connections that lead to stability, health, and prosperity. So we're proud to be part of a community-supported solution that levels the playing field for people who can't afford even the lowest bail amounts. Thank you. I'd be happy to answer any questions, including about 8 years worth of data that we have from doing this.
Very good. I have one quick question for you. What's the average amount of the bails that you all post and help people with?
I can only speak for Just City in Memphis, and even then, roughly. These days, it's north of $3,500. We have a limit at our bail fund of $4,000. So it's getting close to the limit of what we'll pay, but the average is between $3,500 and $4,000.
Okay, thank you. And I have Representative Salinas, ma'am, you're first on the list.
Thank you. I've seen a lot of, just kind of skimming through some of the data on this and the percentages, but oftentimes people are leaving out the sample size, which is important, right? Because if you have 5 people and one person doesn't show up, that's 20%. Right. And that, so you said 98%. What is your sample size?
That includes everyone we've ever paid bail for across more than 8 years, 9 years now. It's a little less than 2,000. Last year, for example, we paid bail for 313 people.
Oh, that's a really good sample size.
It's a lot of folks.
Okay.
Very good. I have Representative Johnson. You recognize.
Thank you, Mr. Chairman. I think this is really important, and I like the fact that you have, turned this a community solution, and it ties people to their community. A lot of times that's what we see. The problem is in the justice system is people don't have those ties to the community, so I appreciate that. So how do you think this bill will affect what you all are doing if it were to pass?
Well, after meeting with the sponsor and after this amendment, we will continue to do exactly what we did. When this becomes law, we won't have to change anything that we do.
But do you have a concern that the amounts might change or the levels might change or something like that? And
Representative, I'm here to represent the 313 people that we paid
Yes.
bail for last year and the almost 2,000 families that we've helped over the last 10 years. I have concerns when we begin to regulate things like this, but I want to continue to support the people in my community, and this amendment allows me to do that.
Thank you.
Very good. Representative Travis. You recognize, sir.
Thank you, Mr. Chairman. And just a quick question. What do you charge for your bail bonds?
There's no charge, as I said in my remarks. There's no, so-called skin in the game. We do not pursue people. We're not bail bondsmen. We don't have bounty hunters, and we tell folks that. And we have a document that they get that says we're a charitable organization, that this is a gift. But it makes very clear that if they return to court, we get the money back, and then we can help someone who's in their position in the future. And that idea of paying it forward is, I think, what gives us a 98% appearance rate. So it's just, it's a function of our nonprofit. It's something that we believe helps our community. It certainly helps that family. We wish we could help more, but it is complete charity.
It's just complete charity?
Yes, sir.
That's pretty impressive.
Thank you.
Very good. Members, that's all I have for our guest. Any additional questions? I have Representative Salinas.
Did we have another witness or is it just one person?
It is just one person. Any other questions? All right, members, any objection going back into session? All right, seeing that, thank you for being here. All right, members, we're back on the bill. Any questions for the sponsor? All right, seeing none. Any objection to the question? All right, seeing none. Madam Clerk, if you'd open the board, members, we're going to be voting to send House Bill 1450 as amended to Finance, Ways and Means. All those in favor vote aye. Opposed, vote no. Has ever been voted? Would any member wish to change their vote? All right, Madam Clerk, if you would take the vote.
Mr. Chair, you have 15 ayes, 4 noes, and 0 present not voting.
Very good. House Bill 1450 as amended is moved in Finance, Ways and Means.
Thank you all.
And that brings us to item 6. Representative Martin, that's House Bill 1454. Sir, you have a motion and a second, and I don't see an amendment here.
No,
so
sir.
You are properly recognized.
Thank you, Chairman and Committee. Leader Lamberth passed language in the 113th General Assembly which authorized the death penalty for convicted child rapists. Hamilton County's District Attorney Cody Wamp has since brought one of these cases to trial, and yet she sought to seek the death penalty but realized that the current list of aggravating circumstances was inadequate to sentence these and future defendants to death. This bill updates the list of aggravated circumstances to fit the horrific criminal conviction of a rape of a child. Section 1 adds a dozen aggravating circumstances to Tennessee's code, and in order to sentence a convicted criminal to death, one of these aggravating circumstances must be proven by the state. I appreciate DA Wamp and certainly Leader Lamberth for their commitment to safety and the rule of law. And with that, Mr. Chairman, I stand ready for questions.
Thank you, sir. Members, any questions for our sponsor? All right. Seeing none, any objection to the question? I'm seeing one. I got you. I miss you. Representative Johnson, you recognize.
Thank you. And I guess it's kind of the same thing. What I've been told by victims is that when the death penalty is on the table, a lot of people don't report. And so because it's a family member, very often in a large percentage of these cases, it's a family member that created the act. And yes, it's heinous, but we already have 100% time served, life in prison. But what a lot of victims and victims advocates are afraid of is that it's going to prevent people from actually pressing charges because they're afraid if it was an uncle, a brother, they are going to be put to death. And so they won't go after that. So I feel like anything that we do that might prevent a victim from coming forward is very dangerous when we already have this as 100% time crime and punishable by life in prison. So does it concern you at all that this could keep victims from coming forward in the case specifically of a family member?
Representative Martin.
My greater concern is that we have child rapists and child molesters that are on our streets affecting more innocent children. This is something that people don't get healing from.
Right.
This is something that is the worst of the worst that can happen in humanity. And I think that the worst of the worst deserves the most stringent penalty that the state of Tennessee can find in a lawful manner. And that's why I'm for this. And, you know, I have friends, you had mentioned anecdotal evidence. I have a friend of mine whose brother raped his grandchild and is in prison. And I asked him, I said, what do you think? He said, absolutely. This is the law and the bill that needs to happen. And he was talking about his own family that he loves, which is tragedy above tragedy. But these people are not able to offend and hurt other children in the future. And that's really what this bill's about.
Yes, and I understand that. I know that there are victims on both sides of this issue, absolutely. But again, the concern becomes those not coming forward. And if you are in prison for the rest of your life, you also will not reoffend. So it's, you know, the death penalty is not really about not reoffending because we can already do that with life imprisonment with no possibility of parole. But thank you.
Very good. Members, any additional questions? Representative Salinas, you're recognized.
Yeah, this is something I've been struggling with. I think in subcommittee, I voted present, not voting, because I do agree with what Representative Johnson was saying. So since we already have a sentence that's 100% time served, this would be replacing that, or is there two options of either, like, or?
This would be a matter that would be determined by the jury, and it gives them as an option. It would have to be proven on these aggravating circumstances, and it would have to be proven to the jury at this. So it does create an option. But in every situation, I don't think that the death penalty could be pursued, but this allows that as an option. And so that's why the district attorney has brought this to me, and that's why I stand before you, because we want to make sure we have the safest community.
Any follow-up?
That's it.
Very good. Members, any additional questions? Not seeing any. Any objection to the question? All right, seeing none. Madam Clerk, you'd open the board. Members, we're going to be voting to send House Bill 1454 to calendar and rules. All those in favor, vote aye. Those opposed, vote no. Has every member voted? Would any member wish to change their vote? All right. Madam Clerk, you take the vote, please.
Mr. Chair, you have 15 ayes, 3 noes, and 1 present not voting.
Very good. House Bill 1454 is moving to calendar and rules. Thank you.
Thank you, Chairman and Committee.
All right, members, that brings us to item 7, House Bill 562. Sir, you have a motion and a second, and I'm looking at, I have 2 amendments here, 14273 and 15089.
Thank you, Mr. Chairman. Yes, sir. Drafting Code 7268 is the amendment that rewrites the bill for clarity. That's the amendment that I would like to put on. It supersedes, I'm sorry, I misspoke, Mr. Chairman. It's Drafting Code 15089.
Very good. That's what I have. You got a motion and a second. Members, we want to go ahead and adopt this amendment. Any objection? Seeing none, all those in favor of adopting House Amendment 15089 to House Bill 562, say aye. Aye. Opposed, say no. Ayes have it. Sir, we're back on the bill and you're properly recognized.
Thank you, Mr. Chairman and committee, and appreciate your patience on that. The amendment rewrites the bill for the purposes of clarity, but makes only 3 changes. In section 1B3, the words "or federal" have been removed. Instead of saying as a result of violation of state or federal law, it now says as a result of violation of state law. Secondly, the penalty for the violation, this legislation for local officials has been changed. That's something I'd heard from lots of folks. Leader and I spoke about this last week. The person harmed by the violation of this legislation will no longer be able to bring civil action against the local officials. Instead, If local officials are accused of violating this legislation, they will be subject to ouster proceedings. And if the public official is ousted from their position, they're ineligible for election to the same office for a period of 5 years. We thought that seemed apropos. We talked through it. And the effective date has been changed. 562, colleagues, as amended, this piece of legislation applies to lessons learned from the COVID-19 pandemic. It reaffirms that all legal work is honorable and serves a purpose in our communities. It reaffirms that each Tennessean has a right to pursue a lawful career of their choosing. It reaffirms the ability to earn a living is a basic civil right. It reminds us, as Thomas Jefferson so eloquently articulated, that the role of the government is to secure the rights of the people, and establishes a way for Tennesseans to seek remedy if they're prevented from carrying out their lawful duties. With that, Mr. Chairman, I'll stop and take any questions y'all may have and ask for a favorable consideration.
Very good, members. I have 2 people on the list to speak. Any objection to go out of session? Seeing none. And I have Mr. Patrick Shahan. Are you here? You are. And then I have Austin Travis. Mr. Travis. Okay, we're going to stick with him. Okay, very good. We have 1 speaker then. All right, sir, I believe you have experience here. So your mic's on, 3 minutes. Just let us know who you are, who you're with, and we'll go from there.
Thank you, Mr. Chairman and members, for the opportunity to speak today. My name is Patrick Sheehan. I'm the director of the Tennessee Emergency Management Agency. I want to acknowledge up front that team's concerns are not with the intent of the bill, which I agree with. Rather, our concerns are that the way in which House Bill 562 is written could unintentionally jeopardize the legality of emergency protective orders, including shelter-in-place, curfew, and evacuation orders which are essential for protecting lives and property during emergencies, and thus are frequently utilized by local officials across the state. These orders often necessarily include exemptions for certain professions whose presence is necessary to support an effective response, while restricting access for an area to all others. While some of these professions may seem obvious, firefighters, law enforcement officers, first responders, there are often exemptions for less obvious private sector professions, including insurance adjusters, debris removal companies, and critical infrastructure employees. Some real-world examples of this include the 2016 Sevier County wildfires, where there were exemptions for insurance agents and debris removal, and the 2020 Christmas Day bombing on 2nd Avenue, where AT&T staff were exempted. Potential scenarios could also include TVA facility emergencies resulting in shelter-in-place orders. Under the language as amended by the committee today, an individual whose profession is not exempted from such an order may interpret it as classifying the exempted professions as essential and all others as non-essential. This bill would provide an avenue by which mayors who issue these orders could be subject to ouster proceedings. If removed, they could not seek office again for 5 years. House Bill 562 would provide the individual with a private right of action against the governor if he or she has issued the order. Responses in Tennessee are nearly always locally led. This means mayors would be particularly at risk under this provision. Additionally, should an event reach a magnitude necessary for the Government to act, he or she could be sued over the order. In emergency situations, these orders are time sensitive and critical for the protection of the lives of Tennesseans in harm's way. My concern is that this legislation may cause mayors to hesitate before issuing necessary protective measures out of concern for being removed from office for orders which are not intended to violate this proposal, but which may be read as doing so. In emergency response scenarios, seconds matter, and any delay in issuing protective orders could place the lives and safety of Tennesseans, including both the general public and first responders, at risk. Glad to answer any questions. Thank you.
And thank you for that explanation, sir. Members, any questions for our guests? I have Representative Salinas. You're recognized.
Thank you, Mr. Chairman. How much flexibility is needed, in your opinion? Because one of the things that I think about is, for example, we're on a fault line and I represent Memphis, and like there's this, we know that an earthquake is coming, but we don't know when. And a lot of the elected officials don't have experience in dealing with an earthquake because it's not something happens often, right? It's not like a tornado or some weather. Does this bill, would that prohibit some flexibility in addressing a future natural disaster like that?
That's our concern.
Okay, can you speak more to that, please?
The amount of uncertainty. So we know that an earthquake will happen. It's a matter of when. Anyone that tells you they know when is not honest. So what we do know is what's possible, and it's a phenomenon called random about a rate. So we know that earthquakes occur with some relative frequency in the new Madrid seismic zone. And they've been powerful. So Reelfoot Lake did not exist before 1811, and the power of the earthquake was able to reshape. So restricting access to areas to prevent looting, to ensure that only homeowners or those that would need to be in an area, we're concerned that this would limit the ability of mayors to issue those kinds of orders.
Thank you. And from my understanding, like a lot of the time, it's like, it could be tomorrow, it could be 50 years from now. So we don't know when.
I hope it's 1,000 years from now.
Yes, me too. Thank you.
Very good. I have Representative Powell, next on the list. You're recognized.
Thank you, Mr. Chairman. And first of all, I haven't seen you since the Fern incident of the winter storm. So I appreciate everything your agency did to help get Nashville and the entire state back online. So thank you for that. My concern here is, I had firefighters up in my office yesterday, and we're actually talking about the response there. And sometimes it's necessary for emergency personnel to try to get people to stay and shelter in place, because if they go out, then it can only create more emergencies. I know in that situation, there were down power lines, people were driving over, they didn't know they were line. I mean, there were all kinds of issues that we wouldn't even fathom. So I guess my question for you is, in these types of situations, I know we don't want to keep people from working, but sometimes isn't it in the public good and safety overall so that you can get things back in order, working more quickly? And sometimes having more people out and about can create even more problems rather than just having people try to stay in.
It can. And, with the ice storm, mobility is limited, so that's a little less troublesome. But in the aftermath of the wildfires of 2016 and some other some tornadoes, what you have too are disaster tourists or looky-loos, people who are just, for whatever reason, morbidly curious. We had the same with Helene, where folks who were not engaged in relief efforts find some reason to make a road trip to go and out of some morbid curiosity. And they're in the way when they're doing that. And they are hindering the rights of the people, in my opinion, who are residents there, who are trying to get their lives back together.
Thank you for that. Next, let's have Representative Alexander.
Thank you. And thank you, Commissioner, for being here. We appreciate you so much. I just wanted to say I lived Hurricane Helene with you guys. And the importance of our mayor putting restrictions on who got on the roads and who didn't. When we had roads washed away, thousands of trees down, possible injury to people if they got in the way of heavy equipment. It was vital that you all had the ability to work with the mayor and to say who was essential and who was not, because it was essential that you got us help as quick as possible. So thank you.
Thank you, ma'am.
Very good. Now, to follow up on that, I want to also echo that with regards to the 2016 wildfires in Gatlinburg. That was a disaster, and the support that we got as quickly as we did. I know Representative Ashley was a fireman at that point in time and was fighting those fires right in the middle of it. We were talking about that last night, but also just as Representative Alexander said, your service and work, and it was important that our mayor had the ability to do what he did at that point in time. So next on the list, I have Representative Johnson. You're recognized.
Thank you, but I think my issue's been addressed.
Very good. Members, any additional questions for our guests? All right, seeing none. Any objection to going back into session? All right, seeing none. All right, we're back on the bill, members. Any questions for our sponsor? Representative Fritz, you're recognized, sir.
Thank you, Mr. Chairman. Just a couple follow-ups quickly. I do appreciate the work that our emergency services folks do for us. I think we're conflating a couple things. This has happened. We've ran this bill. It's my fourth time to get to run this piece of legislation, so I've gotten accustomed to it. Article 1, Section 21 of the Tennessee Constitution said, "No man's particular services may be demanded without consent of the representative or without just compensation." And there's not only the finality of that statement in our Constitution, but there's also the intent of that government does have boundaries that it operates within. Government should pause before they declare a lawful citizen non-essential. Government should stop and think about that. I think we're conflating, friends, that the declaration of someone as being non-essential is a hugely offensive statement for government to make to a citizen of the state of Tennessee. It takes us back to the flashbacks of suggesting that Rosa Parks was less essential than the white folks that wanted to be on that bus. It takes us back to a time when we declared folks so non-essential that we would sick dogs on them. We must think about these things. Our civil liberties, I'm of the opinion, our rights come from Almighty God. And I think the right to earn a living is one of those rights. And certainly all of the people that are supportive of this piece of legislation don't want to impede the response to the horrible flood of Helene. I too was up there a couple days after that took place. Certainly don't want to impede addressing the horrible fires up in Gatlinburg. But what we did a few years ago caused tremendous financial hardships on those whose occupations were listed as non-essential, but who did not have the capability to work from home, or their occupation was not one that they could practice from home. In July of 21, the Sycamore Institute reported that as late as June of 21, Tennessee had 40% fewer small businesses than before the pandemic. 40% fewer small businesses. Some of that was a result of these declarations of non-essential. Our role in government, friends, I'll close with this, is not to pick winners and losers. It is to provide oftentimes that emergency response. But surely, my friends, we can do this without issuing something so offensive as to pick a man who is a barber, a woman who is a cosmetologist, and declare them non-essential, less than their fellow citizens. We did that, and we should learn from it. So I would appreciate your favorable consideration. Thank you.
All right, very good. First note, I had Representative Travis, you recognize.
Thank you, Mr. Chairman. Move previous question.
All right, members, you've heard the motion. Any objection? All right, seeing none. Madam Clerk, if you'd open the board. Members, we're going to be voting to send House Bill 562 as amended to calendar and rules. All those in favor vote yes. Opposed vote no. Has every member voted? Any member looks to change their vote? All right. Madam Clerk, you take the vote.
Mr. Chair, you have 10 ayes, 9 noes, and 0 present not voting.
Very good. House Bill 562 as amended moves to calendar and rules.
Thank you, Mr. Chairman. Andy.
That brings us to item number 9, House Bill 2041. Representative Parkinson. You got a motion and a second. Members, I believe we've already adopted House Amendment 13429. We have, as a matter of fact, and this was heard at the end of last week's meeting. We ran out of time. Representative Parkinson has explained his bill. Members, do we have any questions for Representative Parkinson? Chairman Doggett, you recognize.
Thank you, Mr. Chairman. I move previous question.
Very good. Previous question has been called. Is there any objection? All right, seeing none. Members, looks like we're voting. Madam Clerk, you go ahead and open up the board. Members, looks like we're going to be voting to send House Bill 2041 as amended to calendar and rules. All those in favor vote aye. In just a minute. There we go. All those in favor vote aye. Opposed vote no. Has that member voted? Any member? Let's change the vote. All right, very good. All right, Madam Clerk, you take the vote.
Mr. Chair, you have 19 ayes, 0 noes, and 0 present not voting.
Very good. House Bill 2041 as amended is moving to calendar and rules.
Thank you, Mr. Chair, and thank you, committee.
Members, without objection, we're going to move to item 29. That's House Bill 1245.
Motion.
And I'm looking at House amendments. The latest amendment is 15403.
Yes, Mr. Chairman, that is correct. It makes the bill.
You have a motion and a second. Members, do we want to go ahead and adopt this amendment? Any objection? Seeing none, all those in favor of adopting House Amendment 15403 to House Bill 1245, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're recognized.
Thank you, Mr. Chairman and members. If you remember last year, House Bill 40, which is now Public Chapter 418, we asked TASER to do a study assessing juvenile detention capacity in Tennessee. After the passage of that, they did a great job, 81 pages, good information. But Senator Roberts and I came up with some additional questions, and that this TASER study request would be to study the current structure of licensing and oversight mechanism for residential facilities licensed, approved, operated, or contracted by the Department of Children's Services or a juvenile court for the placement of juvenile detained prior into an adjudicated hearing or who have been adjudicated delinquent and committed to DCS custody. And there's a few more minor questions we would like TASER to study, Mr. Chairman.
Very good. Members, any questions for the sponsor? Any questions? Seeing none. Any objection to the question? Seeing none. All right, members. Madam Clerk, you'd open the board. Looks like we are voting. We're going to vote to send House Bill 1245 as amended to Finance, Ways, and Means. All those in favor vote aye. Opposed vote no. Every member voted. Any member will change their vote. All right, Madam Clerk, you take the vote.
Mr. Chair, you have 19 ayes, 0 noes, and 0 present not voting.
Very good. House Bill 1245 as amended. Sir is moving to Finance, Ways, and Means.
Thank you, Chairman and Committee.
All right, members, just one moment. If we could go to item 19, that is, yeah, thank you.
Sorry, we're changing that. House Bill 1968 by Chairman Farmer. I have a motion and a second. I don't see any amendments on this legislation. Is that correct, Chairman Farmer?
That is correct.
All right, let's go. Representative Landreth, you're recognized.
Thank you, Madam Chairman. She seemed reluctant to recognize me. But to Chairman Farmer, and I know we've talked about this, but I want to make it a public conversation. The Opioid Abatement Council that has been distributing these funds, I know that we're not going to touch that this year, but I have had some concerning reports from my district, and I think others have as well, on sometimes they'll do a one-year grant, even on a program that's successful, and then not carry that grant through. It really hurts continuity of care. There's some specific treatment programs, inpatient, outpatient, that could use some funding. And it seems like a lot of this funding has gone to administrative cost and staffing. And I know this bill just adds a few more entities to the opioid abatement, fund that's there. But I do hope that we will look at this fund if those of us here are blessed to be reelected. And if we come back, I hope we look at the structure of how it's going. And if those folks are paying attention today, I hope they really look at how these funds are really being used in our community, because they could be used for phenomenal good. And in some instances they are, but I just have some concerns that in other instances we're just generating salaries. So just wanted to mention that, Chairman, and I don't know what your thoughts on it. Well, I do know what your thoughts are on it, but I just want to at least mention it.
Chairman Farmer. You're recognized.
Thank you, Vice Chair Davis. Members, what this does is allows us to accept money from two additional pharmaceutical companies that would go into our opioid abatement monies to the tune of about $400,000. So with that, I'd move passage.
All right. Representative Johnson, you're recognized.
Thanks. And this is kind of to the previous point from my colleague. I certainly support this going to other folks. Is there anything in those abatement rules that say, like, how much, what is their percentage allotment like to prevention and things like that? I'm just curious about that legislation because prevention is so important. Does any of those funds go to prevention or?
Chairman Farmer, you're recognized.
And Representative Johnson, it's been a few years since we passed that piece of legislation. I know it was very detailed in how those monies were distributed through our municipalities, locals, and the state government. So I will get you that roadmap if you would allow me to do so after committee.
Yeah, I'd love you to do that because that's something people always ask me about. They feel like prevention is so important. So I just would like to revisit what that about is.
I'll be happy to get that to you.
Thank you.
Representative Salinas.
Do you know what drugs are included in those two corporations?
Representative Farmer. Chairman
Yeah,
Farmer.
they would have had to distribute opioids and contributed to the epidemic that we are still feeling today.
Okay, but you don't know
Salinas.
you don't know which drugs are opiates that are under the intellectual property of those two?
Chairman Farmer.
I do not.
Okay, thank you.
Representative Littleton.
Thank you, Mr. Chairman. I call for the question.
Question's been called. Any objections to the question? All right, all those in favor of voting for 1968 to move forward to Finance, Ways and Means, let's put it on the board. Clerk, can you please open the board for a vote for yes, no? I'd love to, yeah. All right, clerk, can you call the vote, please?
Madam Chair, we have 16 ayes, 0 noes, and 0 present not voting.
Chairman Farmer, your bill moves forward to Finance, Ways and Means.
All right, members, we're gonna try to get one more in here. Item 33. That's item 33, House Bill 36 by Vice Chair Davis. You got a motion in a second. Members, I'm looking at House Amendment 13156. Very good. You got a motion in a second. Members, we want to go ahead and adopt this amendment. Any objection? All right, looks like we are voting to adopt House Amendment 13156 to House Bill 36. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended. And Vice Chair Davis, you're recognized.
Thank you, Mr. Chair. Thank you, committee. This piece of legislation is a reporting bill. It will have to do with the data in regards to parole and medical furlough.
Members, any questions for Vice Chair Davis? All right, seeing none. Any objection to the question? Representative Johnson, do you have a question?
Yeah, I guess a little more specifics about what it does. I see what it's related to, but what does it actually change? Because I'm not remembering this one.
Vice Chair Davis.
Thank you, Chairman. This piece of legislation, what we have done is we have amended it to where it's a reporting bill. So we will get some information from TDOC with regard to the number of people that are eligible for medical furlough, those that are also potentially to try to see how many are being able to move out and or move to various facilities and their care. We're wanting to really look at that sort of population and that cohort within our prison system.
Thank you.
Very good. Members, any additional questions? All right, seeing none, any objection to the question? Seeing none. Madam Clerk, if you'd open the board, members, we're voting to send House Bill 36 as amended to calendar and rules. All those in favor, vote aye. Opposed, vote no. Has that ever been revoted? We didn't wish to change their vote. All right, Madam Clerk, if you would take the vote.
Mr. Chair, you have 17 ayes, 0 noes, and 0 present not voting.
Very good. House Bill 36 as amended is moving to calendar and rules. And members and folks, it looks like all the times of the day, so we'll be adjourned until next week. And no, we'll roll all remaining bills to next week's calendar.